When you hire a lawyer, go looking for one who is both smart and competent, and not somebody who is lazy and negligent. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. If I were going to hire a lawyer for myself, one of the things that I might do when I sat down with that lawyer in his office, I'd say, look, before we get to discussing my case, let me ask you a couple of questions. What's the last book you read? What did you get out of it? Tell me about the last continuing legal education course you went to. What did you get out of that? Now, a lawyer might be offended by those questions, but if he is, he's not the lawyer for you. Because if he is a good, smart, well respected lawyer, he's going to have read something recently that he really liked. Because most good lawyers read. And as you might guess, we are voracious readers because we have to read in our work life. We also, when we go home, we read. I could tell you any number of books I've read this year, and a lot of them I haven't actually sat down with the book. I've listened to them on Audible when I've been driving someplace. And for any of you who may be interested, here is a list of books that I've read in the last year. As you can see, I have a pretty varied taste, and I think I'm like most other good lawyers in this regard. I enjoy books that way. Some people don't. My wife, for example, says it makes her fall asleep, which is a really good reason for her not to listen to it while we're driving or while she's driving. But those are the kinds of things that you look for in a lawyer because you don't want somebody who hasn't been to anything except a free CLE course on something outside of their area of practice. In other words, if you have somebody who's a personal injury lawyer and they went to a CLE because it was free and it was on bond work, well, again, why would they do that? They did that just to satisfy the bar, and that's not a good reason. You want somebody who keeps up with what's going on in the law. And you want somebody who understands all of the key things about the law, especially something like, I don't know, statute of limitations, how soon you'd have to file a case, that sort of thing. So that's what we have going on in this case today. And again, it's not Florida man, it's Florida woman this time. It involves some really odd behavior by this lawyer in representing clients. So this involves Andrea Poviliatis, a Florida lawyer. She was admitted to the bar in December of 1997. She resided and practiced law in Brevard County, Florida at all times. And the respondent here, that Poviliatis, neglected to file suit on behalf of a client and misled the client into believing the suit had been filed and a settlement had been received. Respondent then paid the client the alleged settlement funds from her personal checking account without providing a contingency fee closing statement or settlement agreement. During the bar's investigation, she made misrepresentations to the bar and failed to respond to written investigative inquiries. Now, that little bit of weasel wording right there, misrepresentations to the bar, basically that means she lied her head off. She didn't report to the bar her no contest plea to a reckless driving involving alcohol conviction. And finally, an investigation of her trust account showed that she shared legal fees with non lawyers. Now, that's a no no. You can't pay a non lawyer to send you or bring you a case. That's considered to be a violation not only of the bar rules, but it's also against the criminal law in most states. Finally, an investigation, like I said, showed that she had done this and that she had commingled her personal funds with her attorney trust account by dropping her personal funds into her attorney trust account. And you can't do that. In fact, a lot of times lawyers, when they get in trouble with the IRS and the IRS starts talking about liens, they take all their money and savings and they dump it in the client trust account so that the IRS can't get to it, which lasts about as long as it takes for the bar to get involved. And then they wind up, not only do they wind up having to pay the IRS, but they also wind up losing their ticket too. So, so our problem here for Povolatus begins with a guy by the name of Timothy Ray Betzinger, who was arrested and jailed for driving under the influence, even though breathalyzer tests showed that he had a blood alcohol level of zero point zero. After the charge was dismissed, Betzinger hired respondent to file a lawsuit against the officer and the law enforcement agency for the wrongful arrest. Respondent advised Betzinger that she estimated the value of his case at about $100,000. She executed a contingency fee agreement, and then they had conversations over the next 18 months about the litigation. Well, there are always going to be statutes of limitation, and those run from the date of the incident. So, depending on when he came to her and when this happened, she could have been up against the statute of limitations fairly early. The respondent never provided him with a case number, nor did she tell him where the case was filed, but she did tell him that she'd filed the case. And then she advised him that they had offered $10,000 to settle the case. Betzinger declined. He thought it was insufficient. And then in March of 2023, she called him and said, "Hey, look, they've offered $15,000 to settle the case," and he accepted. Respondent directed Betzinger to come to her home on March 22nd, 2023 to receive the funds, and he got the $15,000 check out of what appeared to be her personal checking account. So he asked her, "Hey, where's the paperwork I got to sign? Don't I have to sign a release?" She said, "Yeah, I'll get that for you and send it to you, and you can do a DocuSign." So that's what she did. He signed a release and trust agreement, but nowhere in there did he release the claim against the city that had wrongfully arrested him. So he became concerned that he might not have received the proper amount of the settlement, and Betzinger never provided him with any document that purported to be a settlement agreement. So he called the law enforcement agency that he thought he was suing, and they said, "We don't know nothing about no lawsuit. Sorry, Charlie." And they offered to tell him to, go call the League of Cities if you think you got a case. Well, the League of Cities hadn't settled the case for $15,000, and that's where respondent said he knew that there was something wrong. In her written response to the bar, the respondent stated that she sent the release to Betzinger in 2023, and he accepted the terms and was paid the $15,000. But the bar staff investigator interviewed the respondent on September 27, 2023, and the respondent told the staff investigator there was no court case filed because it had settled pre suit. However, the staff investigator asked for the name of the individual or entity with whom she'd engaged in settlement in negotiations, and she replied merely insurance, without providing the name of the insurance company or any documentation or emails showing the settlement negotiations. Respondent also explained to the investigator that she did not provide a closing statement when this was a contingency fee case because she decided to handle the case pro bono and took no fees or costs. The reason she decided to take it on pro bono is because she was paying this out of her own pocket because she had screwed up and she hadn't, you know, filed the case when she should have. So they did further investigation and they found that the check came from a settlement she made in another case where the amount of her fees were $100,000. So she took this $15,000 from $100,000. And again, you can't do that. I mean, the other guy got all the money that he was due, but this guy did not get anything like what he was due because she never even tried to file the case, apparently. So the respondent dispersed some of the money to Manlove, the guy that had the higher case, leaving a balance of $166,000 in her trust account. Thereafter, in the Manlove case and four additional client settlements, respondent dispersed earned fees to herself in periodic increments over at least 6 months, $10,000 at a time, or in multiples of $10,000. So that also violated the trust account rules because you can't leave earned fees in your trust account. And then she paid off one of her staff, a guy by the name of Lou, because they'd brought her cases. The grievance committee found that she failed to show good cause for failing to respond to official bar inquiries because after they figured out that she was lying and they asked her specific questions that she knew a truthful answer would implicate her in and get her disbarred, she simply stopped responding. And so the 18th Circuit Judicial Grievance Committee filed an order to show cause. Supreme Court ordered the show cause. She didn't respond, and they suspended her for contempt of court. And then in April, the Supreme Court issued its order and found her to be in contempt and suspended her from the practice of law permanently, essentially disbarring her. In almost every lawsuit that I have ever filed, there is a period of time from the date of filing until the date things start moving. In other words, the defendant responds, discovery is exchanged, depositions start getting scheduled, that sort of thing. That approaches somewhere between 90 to 180 days. So it might take 6 months to get things moving because lawyers have to coordinate each other's schedules. And if I've got a deposition in Poughkeepsie on Monday, I can't be at a deposition in South Florida on Tuesday without making some superhuman arrangements. And generally speaking, I'm not super lawyer. I can't, you know, bound along like Superman can. So there is a huge problem with getting things scheduled early on in the case. As the case gets moving and everybody understands what's going on, things move a little bit faster. But the very first thing you should do 30 days after you've met with a lawyer and he's told you that you have a case is you should ask for a copy of the petition or the complaint. A complaint is filed in federal court and in some state courts, and a petition is filed in state court in some places. You ask for a copy of the pleadings. You want a copy of the pleadings because you want to make sure that your case has been filed. Now, here's another tip. Every document that is filed in a federal or state court will have a timestamp and a case number and case name, or sometimes a case name, but always a case number on the document itself. That's very important to get that. And if you don't get that, and somebody tells you that it's been filed and they can't produce that for you, well, anybody can type up a complaint or a petition and hand it to you and say, yeah, that's been filed. But if it has been filed, it will be, if it's in federal court, it will be on the PACER system. And anybody who wants to can get a PACER account. As long as you agree to pay for the retrieval of documents, you can get a PACER account and you can make sure that everything has been filed. And as a result of that, I think it's important that you always get a copy of the file stamped complaint. And if you find that the complaint is not on file, then you have serious problems with your attorney and you need to rectify them. You either need to go to his office or you need to find some way to communicate to him that you know that your case is not on file because it's not on PACER. Now, there are some cases that have to be filed under seal, like False Claims Act cases. But for the most part, general personal injury cases always are out there in the open, available for anybody to go look at. Also, it's important to note that some states have limits on the amount of fees that an attorney can charge, and they have limits with regard to fee sharing between attorneys. So, if you have an attorney refer you to another attorney and that attorney takes your case, you can ask and you should ask whether or not they're sharing fees and what the split is because you're entitled to know that information. And there's nothing wrong with that because you're not paying more of a legal fee. He's just making sure that the guy who sent you to him gets compensated for the work that he did in your case. But again, it's important for you to know that. And there'll also be a written contingency agreement, and it will state plainly how the fee is calculated because that makes a difference. All of these things get lawyers in trouble all the time. Most of the time, it doesn't reach the level of being disbarred. But lawyers do sometimes, from time to time, make these kinds of mistakes, and you need to be sure that those mistakes don't hurt you as the client. So that's what I have for you today on lawyers behaving badly. Hopefully, you've enjoyed this, found it useful, entertaining maybe a little bit. Thanks so much for being here. Come on back, catch me down here at the beach again next time.
Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.